Good afternoon, and thank you for joining us. I'm Bridget Anderson, the President and CEO of the Greater Vancouver Board of Trade. And welcome to our Business Resiliency series, Navigating COVID-19. Today, we are focusing on how to navigate current hot-button issues regarding commercial leases, including matters such as the question of rent deferral versus abatement, operating costs, and the closure of premises. This topic is a big concern to many of our members, and there are lots of questions to address. In this time of unprecedented uncertainty, we want to ensure that our members and the broader business community can find answers to their most pressing questions. Through a series of free webinars, experts will provide guidance and answer questions to help companies navigate the next step. We encourage you to take part in this discussion. You can engage with us on Twitter, Facebook, and Instagram by using the hashtag GVBOT. And we're also using Slido for today's discussion to allow you to submit questions. Go to slido.com and enter the passcode GVBOT Leasing. Now, before we start, and especially in these challenging times, we want to thank our long-standing sponsors called our Pillar Partners. They include TELUS, CN, YVR, BCIT, and Air Canada. We are very grateful for the support of these 5 organizations whose annual partnerships and commitments enable the important work of the Board of Trade. Thank you as well to our preferred media partner, Business in Vancouver. Today, we are joined by Bill Holder, a partner at Clark Wilson LLP. Bill is a senior mediator and litigator who combines a deep understanding of the law with a wealth of strategic experience and assisting clients on a range of business issues. With a successful track record of 35 plus years in resolving commercial disputes, Bill sees all sides of an issue to help clients find the best solution to their case, whether in or out of a courtroom. Bill, welcome, and I'm going to turn things over to you. And obviously, commercial leasing and rent payments are a huge concern right now for many small and medium and even larger businesses.
Thank you, Bridget. First, I just want to say thank you to the Board of Trade for the opportunity to be here today. This webinar actually arose as a result of my being contacted by the board to submit some written materials on the subject of commercial leasing disputes. And obviously, we're in a very difficult time right now with the COVID-19 protocols in place. And I think landlords and tenants alike are really struggling to try to figure out where they're at right now and where things are going to be in the near and distant future. I have to say just right off the bat that I don't have a crystal ball when it comes to that. I don't think any of us do. And I think, provide guidance in terms of the legal issues everyone's facing. And I'm really happy to get into the questions and answers on this today. I've been talking with a lot of landlords and a lot of tenants over the last couple of weeks. The same issues, same questions seem to be coming up time and time again. I know it's a really difficult time for everyone, and I'm just happy to dive in and get to the questions. If you want to start right in, we'll go for it.
Like you, I was spending hours and hours over the many last weeks talking to our members about some of the issues that they are facing regarding some of their commercial or their rent payments. And really, cash flow is such a huge issue right now for many businesses, and recognizing that they don't have revenue coming in, and so they're not able to pay their rent payment or their lease payment. So let's talk about some of the options first that businesses have and what their legal and financial obligations are.
Right, so the starting point, generally speaking, would be that rent is to be paid. Most commercial leases, at least the modern ones I see, have a clause in them that requires rent to be paid without abatement or set off. Rent in the matter of common law is considered to be kind of a sacred contract. It's something that has to be paid no matter what. So if you sort of take that as your backdrop, the question then becomes, if you're a tenant, all right, if I have to pay the rent, what can I do in these current circumstances? The starting point would be to have a discussion with your landlord. I'll come back to that in a second, though, because in terms of your own business and what you might do, there is the federal government website up and running in terms of the various offers that the government's put forward, the various programs that are in place for tenants and businesses to, try to make ends meet in terms of the current climate. I'm not an expert on the federal government programs. I think all of us have heard about them. I would say as a first step, a business, if you're a tenant and you're struggling in terms of your cash flow, as you've indicated, I would go to that website and I would see what's there available for my business. There's the Canada Emergency Wage Subsidy. There's the temporary 10% wage subsidy program in place. There's the extension of the work sharing program. There's even the temporary changes to the Canada Summer Jobs program. So there's lots of different initiatives in place that have been put forward by the federal government, and that would be my first step as a tenant. And then as my
just
second...
maybe if I could jump in here, I just was listening to the Prime Minister this morning, and he did mention that he's working on some relief for commercial rent payments later this week. Neither you or I have any details of that, but I think it's important for viewers to know that it's something that the federal government has been hearing a lot about, definitely a lot of concern from business right across the country. And so there could be some measures coming there, but and sorry to interrupt, but I just wanted to make sure that people were aware of that because that just happened a couple of hours ago. So when a business is in a situation that they don't think they can pay their rent, how do they communicate that?
So I heard the same from the Prime Minister's office this morning as well. I'm really looking forward to seeing what is going to be put forward on that basis. I think the tenants and landlords both actually are on common ground in a certain extent here. The landlords, generally speaking, would like to see their premises rented, and they don't like to see premises vacant. They don't like to see rent not coming in. At the same token, tenants, of course, have worked so hard to establish those premises as their location. Their customers know that's where they are. They want nothing more to be back in business and to be operating. So when you have two different parties, admittedly on either side of the fence, but both with a similar goal, I think the starting point is to reach out to the landlord if you're the tenant, or vice versa. I've heard of landlords approaching tenants in the first instance, but in both cases, just opening a dialogue and having a discussion about where you are at in terms of your business and your cash flow and everything else, and then trying to see what the options might be, both short and long term going forward. And that just plays into the comment you just made in terms of the Prime Minister's office and the possibility of further programs coming into play here. Most landlords and tenants that I've spoken to were able to arrange some kind of temporary agreement with respect to the April rent when it became due. And I think they did that just on the basis of, look, things are changing so quickly. Why don't we just hold on for 1 month here, see what might then develop before the May rents come due, and adjust accordingly. So I think it's good advice just to open the dialogue up. And I don't know that I would jump too far ahead of things right now. I would have a discussion with my counterpart, and I would try to figure out what we can do just for the time being, because things are changing rapidly and there may be some good news down the road. At least a month from now, or when the May rents come in a couple of weeks' time, we might have a better idea of where things are at and be able to make further adjustments and further agreements.
There are two terms that people have probably heard a lot in the last few weeks are deferral and abatement. What's the difference there, Bill?
Right, so deferral is just a postponement of the obligation. Abatement, of course, is a forgiveness of that obligation. So when we're talking about rent, if a tenant is able to negotiate an abatement of a rental payment with a landlord, that means that payment's being forgiven. It's no longer due. A deferral just means that you're postponing that payment. So that, by the way, was what I heard happening most frequently in the discussions over April rent when I spoke to my various clients. Most of the arrangements put in place were to do with the deferral of April rent. So that meant the rent wasn't forgiven, but the landlord was reaching an agreement with the tenant to just simply postpone the payment of that rent until later. I didn't hear too many situations where the rent was postponed past April. It was just, as I say, a situation where both parties agreed, let's just hold off on the April rent for now, and we'll see what happens in May. We'll meet again and talk and see what we can do. So the deferral was sort of the more common ground. Once you defer the rent, the only other thing you have to think about is when is it going to be paid, because it's still due. And that can be as varied in terms of the solutions as the parties can come up with in terms of their own situations. You have deferral, for instance, where the rent that has been deferred is paid at the very end of the lease, or maybe it's going to be paid 3 months after the tenant gets back open for business, or maybe it will be paid over time as a payment schedule blended in with the balance of the term of the lease. There's all kinds of different options for deferral. The main point being, though, it's just a postponement of the obligation, not a release from that obligation.
There's been a lot of focus on the tenants here, but 2/3 of our members are small and medium businesses, and the landlords, actually, some of them, especially in the city of Vancouver, are small or medium businesses themselves.
Yeah, it's a real struggle. I have great empathy for both sides, but I think we tend to sometimes forget that the landlords can, in many cases, just be small businesses as well. It's easy in our own minds to default to a landlord being a rather large company with unlimited resources. But the reality, especially in Vancouver in certain areas, are that the landlords are, as you say, small businesses themselves. They face ongoing costs. They have to pay heat for the building. They've got to pay security costs. They have to, cover the mortgage for the building. Those kinds of costs don't go away. And when the rent's not coming in, that's a problem. One of the solutions I'm hearing a lot about is when you're looking at a deferral of rent, the landlord may be willing to forgive the base rent, but is hopeful, for instance, that a tenant might pay the ongoing share of operating costs that tenant's responsible for. And so at least that helps the landlord keep things going. It's also in the tenant's interest because the building is being maintained in the meantime.
Let's take a look at some of the questions now that are coming in on Slido and have a look at what people are asking here. So we'll take a look at just the first one. So what rights do business owners, tenants here in this case, have if the landlord doesn't agree to the deferral or abatement? What kind of options are open?
Right, so that's a difficult question in terms of the legal issues. That you could spend hours talking about that. In short, as I said from the outset, the payment of rent is a sort of mandatory obligation. You're supposed to pay it without abatement or set off. If you can't reach an agreement with your landlord on that, you might well find yourself in some kind of dispute resolution process with the landlord. The courts right now are open, but only on emergency type applications and criminal matters, family emergency matters, things like that. So an immediate recourse to the courts by a landlord, let's say suing a tenant for non-payment of rent, might be a bit of a drawn-out process. On the other hand, the landlord might have additional remedies such as being able to terminate the lease. That would see the tenant then applying to the court for relief from forfeiture. And I don't think we have time to get into all those issues today. But the short answer is the rent really will need to be paid unless you can find some avenue to avoid that payment if you're the tenant. The two most common would be the force majeure clause, which you might find in the lease. And secondly, relying on the doctrine of frustration. Again, we don't have a lot of time to get into that today, but most modern commercial leases will have a force majeure clause. A lot of people refer to that as an act of God clause. You need to read the wording of that clause really carefully. You probably will need to have a lawyer look at your particular wording.
So it's not a standard clause or a standard wording?
Yeah, not usually, and there's all different kinds of wording. It can be very robust or it might be rather weak. And, even with those clauses in place, as soon as a tenant can exert some control over the situation and has the ability to try to reduce its damage claim or reduce its obligation in some way, it has to do that. It has to take steps to try to mitigate. Some clauses, by the way, also contain requirements for notice. So if you're a tenant, you need to look at that clause carefully. It may be that you have to put your landlord on formal notice that you're invoking the clause. But the best advice I can give on force majeure is it's by no means a certain deal. You probably should have your particular clause reviewed by counsel. It's not as easy as you might think to make that clause work. The second option, which comes up, is the doctrine of frustration. We have a Frustrated Contract Act in BC, which adopts that doctrine. That is different from the force majeure in the sense that force majeure allows the contract essentially to be postponed or the performance of an obligation to be deferred, whereas a frustrated contract, it's more likely that the court will be asked to simply relieve the parties from performance, period. It might be possible that the court will even just cancel the contract, but you can well imagine the courts are reluctant to do that. There's an obligation. If you can make that contract somehow work, you're supposed to be doing that. So I wouldn't just jump to either force majeure or the doctrine of frustration as a solution. It's a difficult area, and it's worth exploring if you're the tenant, but you're going to need some legal help on that, I think.
And this addresses, I think, most of what is the second question there about what a landlord can do if the tenant refuses to pay rent or to work with the landlord on some sort of deferral plan. Are there other options? I mean, it sounds to me like you're saying, look at all the options like a force majeure, but also to really think about negotiation, because otherwise you could be tied up in the courts for some time.
Right. So the landlord generally would have all of the usual remedies available to it. Some of them may be less practical right now, but in terms of legal theory, the landlord can still pursue its remedies. So the two most common remedies for landlords to invoke are simply to commence a court action to try to collect the unpaid rent. And the second would be to terminate the lease and then commence a court action for any arrears due up to the date of termination, plus damages for the loss of the balance of the term of the lease. That gets a little complicated because the landlord also has a duty to mitigate when it terminates. So that means it's supposed to try to find a replacement tenant, and that could be a very difficult task in today's situation. But those are the two sort of general classic remedies a landlord would avail itself of. There are others like distraint and the like, but those would be the two main ones. The trick there, though, is they both involve court actions. And as we just mentioned, the courts are closed right now except for emergency applications. That doesn't mean you can't commence a court action if you're a landlord. You can file your claim and get it served on the tenant. But in terms of moving the action through the courts, very difficult right now. And so you could count on that action probably taking a lot longer to be resolved than normal. One suggestion I have on that front is, as mentioned, I act as a mediator in these kind of disputes. And if you have two parties that just can't seem to come to an agreement, they're struggling on it, but there seems to be a willingness to at least try, mediation can provide a solution there. A lot quicker, of course, than the court. And it doesn't guarantee a settlement, but it's surprising how often a resolution can be found if you can get both parties into the mediation. And those, of course, can be conducted remotely now. So that can be of real assistance.
Yeah, that's some great insight, Bill. Thank you. So you've been talking to a lot of commercial landlords over the past weeks. What are you hearing from them about what they're doing to offset the burden on tenants?
Right. So the first and foremost step has been the deferral of rent. Most of the landlords I've spoken to have been willing to defer rent. They're not trying to see that kind of an agreement extend too far out. That's for obvious reasons. They're hoping to get cash flow restored at some point. But I think more importantly, I think that's true for both tenants and landlords. They simply don't know what things are going to look like in a month's time or 2 months' time. So the prevailing view seems to be, especially from the landlord side, why should I reach too far into the future? Why would I, for example, just to be extreme, grant a deferral of 1 year's rent? Maybe things will be back to normal in some way, shape, or form in 6 months or 3 months or what have you. So let's just defer for the moment. let's get that agreement in writing, and let's agree to then revisit in a month's time or what have you, and try to make things work. I think that's a prudent approach for both sides.
And there's a specific question here from an organization. So from March 10th, they have had 0 revenue and they have 4 years left on their lease and no revenue until they can provide, I guess, until they can allow people to have large meetings. It sounds like maybe they've got meeting space.
Right.
So what options do they have then? No revenue coming in for, well, over a month now.
It's very difficult if they have no revenue and no means to pay rent whatsoever. They have to have that discussion with the landlord. It may be that there's no resolution to be had there, but at the same time, I think it's worth having the dialogue. You might find the landlord willing to be somewhat creative there. There is also a third remedy, and it's a bit of a pessimistic one, but even when you can't reach an agreement on deferral or abatement of rent, the parties just can't come to terms on that. Another option, and I think this is something that may come up if this drags on for too long, but it would be the negotiation of a surrender of the lease. So going back to that second remedy I spoke of, a landlord could terminate the lease and then sue for the rent that was due at the termination, plus damages for the loss of the balance of the term of the lease. But again, that landlord has a duty to then try to find a replacement tenant. The landlord has to try to keep its damage claim as small as possible. So in the case of this particular party with the 4 years to go on the lease, it's not that the court's going to just award the landlord 4 years of rent for the loss of the term. The court will look at the landlord and say, you're going to need to try to find a replacement tenant. Could that be done in 6 months? Could that be done in a year? And so knowing that that's an obligation of the landlord, a tenant can approach the landlord and say, look, I really just can't do this. If we can't get to a deferral agreement, then let's talk about a negotiation. And that can be payment of a lump sum amount or payment of an amount over time to basically get a release and a cancellation of the lease. You surrender the lease, and then both sides essentially walk. What that amount would be and when and how it would be paid would be part of the negotiation, but that's another way to, be creative in terms of the situation. A bit negative, I grant you. It results in the cancellation of the lease, but at least it, puts a stop to an ongoing obligation and allows both parties to move forward.
Well, let's hope that it doesn't get there for the business community and that this situation comes to an end soon. Yeah. Another question here, that when there is an agreement between a landlord and a tenant around deferring rent payments, what kind of security can a landlord take?
Well, that's completely a matter of negotiation between the parties. There's no obligation on the tenant to provide security, nor is there any entitlement on the landlord to have security provided. Having said that, if you're the tenant and you're trying to persuade the landlord to, in fact, agree to a deferral, and perhaps even a longer deferral than what we've just been talking about, more than a month or what have you, you're going to want to try to sweeten the offer if you can. One way to do that is to provide security so that the landlord has at least some assurance that when it comes time for the payment of that deferred rent, it will actually occur. So that form of security can take, anything that the parties can come up with in terms of their own creativity. It could be a mortgage. It could be security over the tenant's goods, fixtures, trade fixtures, the like. It might be offering a guarantor of some size, letter of credit, what have you. It's just a matter of what the parties might negotiate. Your current lease, and I'm not saying I would suggest this in every case, but the current lease might not have a guarantor and an indemnifier. If the tenant in and of itself wants to try to get a deferral and is willing to put forward a guarantor, at least of the deferred amount, and the landlord can see that that deferral is going to be paid because the guarantor has means, then that's something that might be considered. It ultimately just comes down to, on the tenant side, trying to make the offer attractive, on the landlord side, trying to make sure that it's comfortable with what's being proposed. It just comes down to good old-fashioned negotiation, really.
Well, can a landlord force a tenant to remain open for business?
So in legal theory, the answer to that is yes, but for practical purposes, it's really no. In theory, if a tenant closes, the landlord could seek an injunction from the court, a mandatory injunction forcing the tenant to stay open. But the reality is, I'm not aware of a case in BC where that relief has been granted for decades and decades. It's something that, you know, you can consider as being on the books, so to speak, but for practical purposes, the courts just aren't willing to do that. Rather than provide a remedy where there's an injunction forcing a tenant to remain open, the courts will simply turn to the landlord and say, your remedy is to sue for the rent and or go for damages if you terminate, as we've spoken of. So I think the short answer is a landlord would be unable to force a tenant to remain open.
Well, in addition to that, both levels of government have given direction on essential services. So that would seem to be taking the higher priority than anything else at this point as well.
And that's a really good point too. In certain instances, the reverse side of that is that businesses are being told to close by the government, right? You may have a kind of business which the government is saying you can't operate now. And in those circumstances, you'll find in a lease typically a clause that says a tenant must remain open for business. I tend to feel, this hasn't been tested yet, but my instinct is that a government order forcing a closure versus a clause in a lease requiring the tenant to remain open, I'm kind of feeling the government closure order is going to trump the clause in the lease.
And then this next question was addressed earlier about breaking a lease agreement, but maybe you could just go over that again. So is somebody able to break their lease agreement after the pandemic if they can't stay in business? I think that the same principles would apply, would they not?
Yes, I think that's true. The breaking of the lease, and by that I'm presuming we're talking about a tenant just shutting down, walking from the premises and not paying rent. I think the remedies available to the landlord are the same now as they would be after the pandemic protocols are removed. The landlord, as I say, can just simply insist on performance of the lease by suing for the rent, or it can terminate the lease in the face of the breach and then sue for any arrears plus damages for the loss of whatever the balance of that term is, again, subject to the requirement that the landlord try to mitigate by finding a replacement tenant. So the tenant is going to face the same difficulties now as it will later. The landlord will be looking at the same remedies. And, you know, the tenant's defenses, you're back to the things we talked about. Would a force majeure clause apply? Was it properly invoked? Is there a frustration here that could be given, you know, access to in terms of the Frustrated Contracts Act? Those kinds of things are all in play. But I don't think it changes whether it's now or later in terms of how that would play out.
Good question here from someone about whether there are BC government policies on protecting commercial leases, commercial lessees rather, so those are tenants, from being evicted in the way that there's protection for residential renters.
There's no, I think the answer to that is no, at least not that I'm aware of. There are these standard protections in place that were in place even prior to the pandemic, as far as the Commercial Tenancy Act and the like. But those protections in terms of what a landlord must do as far as taking steps to terminate a lease, etc., those are usually only applicable if the lease is silent on the landlord's rights in default. And that's rare. Most leases nowadays provide, they'll have a whole section in there, a whole group of remedies available to the landlord when a tenant's breached the lease, and the landlord will simply follow whatever that language in the lease is. So it might be, you know, the landlord's forced to give a 5-day notice before it can evict or what have you. But as long as the landlord follows the lease provisions, it'll be okay. It's only when you don't have, for instance, an automatic right of re-entry in the face of a breach spelt out in the lease, that you then go to the statutory remedies that are in place in BC, such as the Commercial Tenancy Act. Those remedies are rather convoluted. You would need, if you're a tenant or a landlord, to probably get some legal assistance on that to navigate those. But as you say, it's rare. 9 times out of 10, it's just going to be the parties look to what the lease says, follow the lease. And in the landlord's case, it's usually pretty straightforward that they're able to invoke the remedies we were just discussing, just following whatever the lease tells them they can do.
This is really, really helpful, Bill. We have time for one last question. I wanted to look outside, or maybe a little beyond the crisis that we're in now. And what kind of impact do you think the COVID-19 situation will have on landlords and tenants, and just on commercial leasing in general? Do you think we're going to see some lasting impacts?
Well, I think in a very technical sense, you're going to see coming out of this a change to lease language generally. I think, legal counsel tend to adjust to events as they happen. And so going forward, when we're in happier times and new leases are being created, I think you'll see different language in force majeure clauses. For instance, there might be provisions spelled out in the leases for arbitration clauses, mediation clauses, mandatory mediation, even frustrated contract language. Those kinds of things might all come into play, but those will develop over time. In terms of just the marketplace generally, I think honestly, your guess is as good as mine. It's a very difficult situation. The longer this continues, the more difficulty I think it will be for landlords and tenants to come back. Trying to predict whether we're going to have a fast rebound or a slow build is, at this stage, at least for me, impossible. I'm not an economist. I'm hoping to see things improve significantly in the short term, but for the moment, what's giving me really a good sense of optimism is pretty much all of the landlords and tenants that I'm talking to right now are talking to each other. They really are on the same page. They're trying to make it work. They're trying to navigate the short term. Who knows what we can do for the long term. Maybe there will be changes and assistance from the government. We'll see. But at least in the short term, I'm very grateful to see the parties doing their level best to try to make their arrangements and sort of weather the storm, at least for now.
And certainly this has been the #1 issue that we've been hearing from our members, and the #1 issue that the Board of Trade has been advocating to both levels of government. So it was really heartening to see some mention of that today by the Prime Minister, and we'll be watching very closely, and we'll let members know as soon as we hear any announcements coming from Ottawa. Bill, thank you very much. That was really helpful today. Really appreciate your time.
No, my pleasure. Stay well.
You too. And to watch this webinar again, please visit theboardoftrade.com on our COVID-19 page, and it will be uploaded within a matter of hours. And to continue this important conversation and to stay connected, we will be hosting a series of free webinars on navigating COVID-19. Over the next few days, we'll be bringing together experts to speak on a variety of topics, such as supporting healthcare workers in a time of crisis, and financial reporting and audit implications. We also have created a business resource page designed to provide planning toolkits and information to businesses and individuals throughout the Greater Vancouver region. This resource page will be updated as new information becomes available, and we'll continue to find and create resources for you as you get through this challenging time. Thank you to everyone for taking part in today's webinar. We look forward to connecting again soon. Be kind, be calm, be safe.